All right, so we're back at class. This is Miranda, part 2, custody interrogation. And this is Law Dog University. And you say, where's he at? Hey, I got a new studio. I got a new classroom for you all. Right? And so I'm getting used to it too, but let's go ahead and start class. I'm going to put this back up here and then put me down here. Hey, hey, hey. All right. It doesn't take too much to get me excited. All right, so now let me. I got Jen here. Jen is my trustee. She's like an out. She's like a shut-in, work away from work studio director. All right, so here's where we're at now. Look, this is Miranda Part 2. Right. Remember, we talked about last time, and those of you that are new to the class, we did the Miranda warnings. Part 1 is on our YouTube channel, but this is Miranda Part 2, and what we talked about is, what is the purpose of all those rights that you hear read on TV shows like Hawaii Five-0 and other cop shows. Right, you have the right to remain silent. Anything you say can and will be used against you in the court of law. If you cannot afford an attorney, one will be appointed to you. You all heard it, Miranda rights before, right? And so what we learned in the first class was this. We learned that the reason why this started was because when the police take somebody into custody down to the police station, in those old movies, the black and white movies where the person is sitting in the police station, they got a big lamp over their head, and these guys in the suits and the hats just standing around interrogating them. And what the Supreme Court said was that because that's a coercive environment, when the police have an individual in custody and that person is being interrogated, because it's such a coercive environment, how do we make this fair? How do we make it comport with what they call due process? Due process comes from the 14th Amendment of the United States Constitution. And what it says is that no state shall deny a person the due process of the law. That's not all it says, but for purposes of Law Dog University's Miranda Part 2 class, that's all you need to know. All right, so because you are entitled as a citizen to due process, when the police take you in custody and want to question you, the question then becomes, well, what process is due? Right? If you're entitled to a constitutional right to due process, what should that process be like? And what the Supreme Court came up with in Miranda was the Miranda warnings. Okay, officers, we realize that you have a duty and a job to investigate crimes. And part of a big tool of your investigation as a police officer is custodial interrogations, right? Talking to suspects, getting a confession, etc. Okay. That's very important, but our citizens have a right to, under the 14th Amendment and 5th Amendment, not to be a witness against yourself, right? Not to incriminate yourself. So the Supreme Court says we're going to come up with Miranda warnings. That'll make the process fair. If you read the person their Miranda warnings, and then after you read it to them, they say, look, okay, I know what my rights are. I want to talk to you anyway. And they waive those warnings. Then go ahead and question them. Right? And so that's what we learned the last class. And again, that video is on our YouTube channel. But I wanted to go over it again because we're going to get into, again, what is custody and then what's interrogation. And so in order for the police to have to read you your Miranda rights, or anybody, two things has to happen. You have to be in custody and they have to question you. And I told you all in my last video, the clients ask all the time, or they would come in my office, right, after getting released on bond. They say, Attorney Lawson, I wanted, the police arrested me and handcuffed me, and they never read me my rights. You can get this case thrown out, can't you? And my question would be, well, after they arrested you and handcuffed you, did they question you? No, he didn't say nothing. Well, then Miranda doesn't kick in. What do you mean? It's my right. They have to read me my rights, don't they? No, only if they want to question you. Two things have to happen in order for them to read you those rights that you hear on TV. Some of you may have heard in person, right? You have to be in custody, and they have to question you. Now, we're going to talk a little bit about what's custody, and then we're going to talk about what's interrogation. See, it sounds easy, being in custody and then questioning. What does that mean? And I bet you most of you don't know, or most of you think you know what it means, but you don't. And this is why this stuff is so much fun. I mean, you could be doing something else right now, but I promise you, man, this stuff is fun as hell. So anyway, so we're gonna get to so here's your Miranda checklist. You got custodial interrogations, right? Custody, questioning, and then so if a client came in and said, yes, I made a statement to the police, did they read you your rights? Yes, they did. But I asked for a lawyer, and they didn't give me a lawyer. Or there was no voluntary, what they call waivers. So not only do the police have to read you your rights, but do you waive the rights? Do you understand what I just read you, son? Do you understand you have a right to a lawyer, a right to remain silent, anything you say can? Do you understand all those rights? Do you want to waive those rights and talk to me anyway? If you do, then you have to sign this. Do you understand your rights, right? And so normally what would happen is the police would have like a piece of paper like this, right? And it would have all the rights, and then you would the client would initial next to each right, showing that they were read the rights, they understood the rights, and they waived it. All right, so anyway, let's get to the good stuff. So this is the Matheson case, right? An Oregon State police officer suspected Carl Matheson of burglary, and they asked him to come to the police station for questioning. Now, I'm going to ask you all, was this guy in custody? Matheson came freely, spoke with the officer, and was not arrested at the time. He was arrested later, and the trial court used evidence obtained during the questioning to convict him. And when Matheson got arrested, Matheson goes to the police station voluntarily. Matheson, I think that's how you pronounce it. But he goes there voluntarily because the cop calls him and says, look, I want to talk to you about a burglary. So he's like, okay, I'll be right down. So he go down there, say, hey, man, Detective so-and-so called me down. He wants to talk to me about a burglary. Sir, have a seat right there. We'll be right with you. So he sits down there. So the detective comes out, asks him some questions. Hey, we got wind that you may have been involved in a burglary. So he makes statements, he being Matheson, that gets him in trouble. So I said, well, after you just told me that, I got to arrest you, Matheson. They arrest him, charge him. He goes to court. Now he comes see you, the lawyer. He says, hey, man, I ain't think the guy was going to arrest me. I went down there. Next thing I know, well, did you talk to him? Yeah. Did he read you your rights? No. What? No, he didn't read me my rights. Are you serious? Yeah. Right. So the lawyer, you being a lawyer, you filed a motion to suppress. What is that, Lawson? That's when you file a motion in court and you're saying, Judge, when the officer talked to my client at the police station, he didn't read him his rights. And because he didn't, I want to suppress, i.e. I want all that thrown out because it violates the Constitution. So that's what you did as his lawyer. You filed it, right? And what did the prosecutor and the police argue? They said, we don't have to read Miranda when we're talking to him. Why? Because he wasn't in custody. Now, you, the lawyer for Matheson, you argue, hey, no, wait a minute. He was in custody because he went down to the police station, and, that's a coercive environment. That Law Dog University professor, Lawson, he told us that the police station creates a coercive environment, and that's why Miranda was created. That ain't what I told you. What I told you was that you have to still be in custody. So the question is, and the question before the United States Supreme, because the Oregon Supreme Court found that Matheson was in a coercive environment when he was at the police station. So it went to the United States Supreme Court. United States Supreme Court said, no, he's not. No custody. And because there's no custody, right, there's no coercive environment, no need to read the Miranda warnings, right? Police officers are not required to administer Miranda warnings to everyone whom they question, nor is the requirement of warnings to be imposed simply because the questioning takes place in a station or house. Miranda warnings are only required where there's been a restriction on a person's freedom. so as to render them in custody. In other words, so that's the test. When you see that, when you see facts like this, or when you see a case like this, how do you determine if somebody's in custody? If the officer doesn't say you're under arrest and put cuffs on you, you can still be in custody. How does a court determine that? How do you determine if the person is in custody, right? And it's a reasonable person test. The test is, and there it is, a reasonable person would not have believed his liberty restrained to a degree associated with a formal arrest. In other words, if you believe that you can leave, I mean, I ain't answering your questions, I'm out of here, right? Would a reasonable person have believed when the police are questioning them that their liberty is so restrained that they can't go, right? Now, keep in mind, when the police, those of you that are new to the class, remember, last class, those that are not new, we talked about like a DUI stop or a stop for a traffic violation. You're not free to leave, but you're not in custody, and the police doesn't have to read you your Miranda rights unless they keep you there for a long time. All right, but more on that in the first video. All right, so there's your test. How do you know if you're in custody or when an officer has to read your Miranda warnings? Would a reasonable person have believed that when they were stopped and talked by the police that they could not go? You know, when you pulled over in a car that you just can't run over, you know, you just can't just leave, right? If you voluntarily come down to the police station and they haven't dragged you down there, then you're free to leave. All right. So now let's test your knowledge. Here's the hypo. All right, so make sure you put your answers in the live feed. All right, so defendant threatens his wife when she moves out, and a week later, her daughter and grandchildren are murdered in their new apartment. So the police go down to defendant's work and tell him that he's not a suspect. They say, "Hey, look, you're not a suspect, but we need to ask you some questions in light of some prior threats you made on your ex." And so he says, "Okay, I'll come down to the station with you." So he agrees. He voluntarily goes down. And the cops take him to the police cruiser and they say, "Look, we have a department policy. It doesn't matter who you are. If you ride in our car, we got to put cuffs on you." They put the cuffs on him. They take him to the police station. And as soon as he gets out the car, they take the handcuffs off. They take him to the interview room. He's interrogated. He makes incriminating statements. They let him go. And then he's charged with a crime, with murder later on. Is that custody? And because what you're asking is, because see, when this guy comes into your office and says, "Look, I went down there. They came to my job. They said, look, they want to talk to me about my ex. They said I wasn't a suspect." Right? And they asked me, was I willing to go down to the police station with them? I told them, yeah, I'll go. They said, well, okay, before you get in our car, we have to handcuff you. That's just the rule, no matter who you are. So I get handcuffed. So so when you got to the station, did they take the cuffs off? Yeah, they took them off. And then what happened? We went back to a room. And then what happened? Well, I thought that, I'll confess. Did they read you your rights? No, they didn't. Well, right? And so now you have to argue. So you're going to argue as his lawyer that that confession should be thrown out of court. Because you're going to try, right? And so the question becomes, was your client, this guy, in custody? If he's in custody, they have to do what? They have to read the Miranda rights. If he's not in custody, then they don't have to read him his rights. So the question on the hypo is he in custody? All right, so I'm going to look at this, and I can't see the live feed with this setup. That's okay. I'm going to go back and look and then see what your answers are. All right, so the Indiana Supreme Court held that a reasonable person would not have believed his liberty restrained to a degree associated with the form. In other words, the Indiana Supreme Court said, no, you weren't in custody. You voluntarily went down there. Any reasonable person in your situation would have known that when they took the cuffs off, when you got to the police station, that you were free to leave. They never told you were under arrest. So no, you weren't in custody, even though it took place at the police station. All right, let's go to our next one. Here's another one. So remember the test now. All right, police officer observes two groups of men eyeing each other right? Gang, right? Three of the men had their hands in their pockets, which the officer took as a gang sign. And so he lawfully comes up and he frisks one, right? Pat them down, make sure they ain't got no weapons. And he feels a bulge in the waistband of one of these guys. And he pulls out a 14-inch hunting knife. And he looks and he says, "Hey, man, what you gonna do with this?" And the suspect responds that he was going to scare the other gang members with it. Now, is that statement admissible? Now, so your client, so the gang member happens to be your client. So he come in your office after he gets out of jail on bond and says and tells you that. Hey, we standing on the corner. Officer comes up, he pats me down on the outside of my clothes, and then he pulls out this big knife. Right? And did he ask you anything? Yeah, what did he ask you? He said, what are you gonna do with this? So I told him I was gonna scare some of these other gang members around here. He arrested me for carrying a concealed weapon. Right? Because there's nothing wrong with that. You can walk outside with your butcher knife right now and wave it around. You can't threaten nobody with it, right? But because it's not an illegal weapon. If you conceal it and you're going to use it for a weapon, then it's carrying a concealed weapon. And we can get into those type of criminal laws later on in another class. But, so that's what your client's charged with. And so you said, well, when he questioned you, did he read you Miranda before you told him you was going to scare the gang members with your knife? You said, no, he didn't read it that. So you filed your motion to suppress. What is that, right? Unconstitutional. He is supposed to read my client Miranda. And the question is what? When the officer went up, patted your client down, and pulled out the knife, was your client in custody? All right, put your answer down. Right, there's your test now. Would a reasonable person have believed that his liberty restrained to a degree associated with formal arrest? Now, the Maryland court held that a reasonable person would have understood that the discovery of the knife on the defendant terminated any consensual investigation and triggered the adversarial criminal process. Now, what does all that mean? And when the cop pulled out the knife from your pants, it was obvious to everybody you was under arrest. It's almost like if you would have had a bag of dope in your pants, right? The cop pulls it out, bag of weed. Weed's illegal in some states, right? But let's say it's illegal in your state. So he pulls out the bag of weed. Now, you know, at that point, without the cop saying anything, man, I ain't free to go. A reasonable person would believe that once they pulled out that knife, that they're in custody. And what does Miranda say? If I'm in custody, you have to do what? Read me my rights. And the Maryland Supreme Court agreed. All right, so let's go to the next one. And this one, right? We talked about interrogation. Now what about Miranda and interrogation? All right, so now what's questioning? Right there. And so now we talked about custody, right? Custody means what? Would a reasonable person believe that he or she was free to go? If a reasonable person would be like, no, I can't, I wouldn't have been free to go, then you're in custody. Now, what's interrogation? And so let's go back and do this one. All right, this is called Rhode Island versus Ennis. This is a fun case. So I want you all to we're going to talk about what's questioning. So shortly after a taxi cab driver who had been robbed by a man wielding a sawed-off shotgun identified. So this Ennis guy was accused of robbing this taxi cab driver with a shotgun. And so the police find Ennis, right? And he's unarmed on the street, but they arrest him after the cab driver identified and said, hey, that's the guy that did it. But they don't find nothing on. They don't find a shotgun on Ennis, but they arrest him. And they read him his rights. You have the right to remain silent, Ennis. That guy over there said you robbed him. You're under arrest for robbery. You have the right to remain silent. Anything you say can and will be used against you. La-di-da, la-di-da, la-di-da. Right? Then when other police officers arrive at the arrest scene, they also tell him, hey, look, we're going to read you your rights again. They do it twice. And Ennis tells him, look, I understand my rights, and I want my lawyer. Right? And so again, He's not waiving his rights. You tell me I have a right to a lawyer. I'm not waiving my rights to talk to you. I want my lawyer, right? So now, when keep in mind, once Ennis says I'm not waiving my rights, I know what my rights are. I want to exercise my right to a lawyer. You cannot question me. That's what Ennis is saying. That's what the law is, right? So he was placed in a police car to be driven to the central station in the company. So he's in the car, in the back, right? The gate, you know how you got those that fence up in the back. You know they keep keep you from coming to in the front seat. Not you, but you know your client. So he's in the back, and 3 cops in the front. Now they not, so they know. Look, he has told us he wants a lawyer. We're not allowed to question him. So what do? So en route to the police station, 2 of the officers engage in a conversation. They start talking to each other. Right? So one of the officers looks at the other and says, hey, you know what, man, there's a lot of handicapped children running around the streets in this area. And because a school for such children was located nearby, the cop says, you know, God forbid, one of them might find a weapon with shells and they might hurt themselves. So now Ennis starts feeling guilty. So he says, hey, look. He interrupts the conversation. And he tells the officers, he said, look, you guys should turn the car around, and I'll tell you where the gun is at, because I don't want to see anybody get hurt. I don't want to see one of these kids pick it up, right? So Ennis was again advised of his Miranda rights, replied he understood those rights, but that he wanted to get the gun out of the way because of the kids in the school area. So now Ennis comes into your office, right? So now the police have charged Ennis with the robbery. And if you're a defense lawyer, part of your argument would have been, if they hadn't got this confession about where the gun was at, is that the cab driver mistakenly identified Ennis. That even though this person robbed this cab driver, no gun was found, no money from the taxi cab was found on Ennis. And so, you know, you have a chance of being, you know, getting your client found not guilty. Not that that's what you want to do. But now you got this statement coming in where your client's telling them where the gun was, which makes him look guilty. So now you move to suppress it. Why? Because your argument is, once Ennis said he wanted his lawyer, y'all wasn't supposed to question him. Now, what's the state arguing? The police said, we didn't question him. We wasn't talking to Ennis. We didn't say not one word to him, man. We talking to each other about, you know, what a shame this would be. And what Ennis's lawyer was arguing is, look, y'all was having a conversation that was designed to make my client say something. You may not have been talking to him directly, but you talking to him after he asked for a lawyer, or you talking to each other trying to get him to say something, violates his Fifth Amendment right. Right? He told you he wanted a lawyer. Once that happens, you cannot try to elicit any statements from him. And that's what you all did when you all were talking up front of the police cruiser. Right? That was Ennis's argument. In other words, Ennis is saying that's interrogation. And the police is saying, we didn't question you, man. That, right? And so the question before the Supreme Court of the United States in this case was, is that interrogation? Real quick, remember, in order for Miranda to be read, you have to be in custody and be interrogated. And if I'm not interrogating you, then I'm not violating Miranda. That's what the state was arguing. That's what the police was arguing. We wasn't interrogated. So even though we read your Miranda, even though you didn't waive and you wanted your lawyer, what we was doing was an interrogation. So it don't apply to us. Right? Now, the Rhode Island before it got to the U.S. Supreme Court, the Rhode Island Supreme Court agreed with Ennis's lawyer. They set aside the conviction and held that Ennis was entitled to a new trial, and they concluded that the police officers in the vehicle had interrogated Ennis without a valid waiver of his right to counsel. All right? And so, again, the issue before the Supreme Court, right? So what did the Supreme Court look at? They looked at whether, when you look at Miranda, when the police officers voiced safety concerns about children finding weapons from the crime, and Ennis interrupted them to say he would show them where the gun was located, is that Miranda? Is that interrogation? And the Supreme Court of the United States said no. The court held that the term interrogation under Miranda referred not only to express questioning, but here's the test now. Even though they said no, because one, the questioning that the officers were doing were not directed at Ennis directly. But it doesn't have to be, because the Supreme Court also said any words or actions on the part of police that the police should know were reasonably likely to elicit an incriminating response from a suspect counts as interrogation. So any incriminating, any statements made by the police where they should probably know that if we make these statements to each other, not to the defendant, not to the suspect, but if we start talking to each other about this, do we think it's going to make him respond? Right? If and again, look at the test, because I'm about to give y'all some quizzes. Right? Any words or actions on the part of the police that the police should know were reasonably likely to elicit an incriminating response. All right, so now here goes your test. Well, before we get to that, here's Justice Marshall, Thurgood Marshall, he dissented. Dissented means I disagree with this ruling. Right? It's like, man, and I'm going to tell y'all why I don't like what my other fellow judges did. And here's part of it. It just says, one can scarcely imagine a stronger appeal to the conscience of a suspect, any suspect, than the assertion that if the weapon is not found, an innocent person will be hurt or killed. What Justice Marshall is saying is, what they were talking about, any suspect would have, a reasonable police officer would know that when they're having this conversation, any suspect with a conscience would have said, okay, let me tell you where the gun is. Therefore, it's interrogation. That's how Thurgood Marshall would have came down on it. But he was in the minority, so this is the law. So there's your test again, right? Any statements said that is reasonably likely to elicit an incriminating response. You got it? Here's your hypo. Frank was arrested for murdering a woman during a robbery in which furs were stolen. Frank declined to answer questions, like, I don't want to talk to you. So later, the detective places some other stolen furs in front of Frank's cell, about a foot away from Frank, right? So hey, Frank, man, we're arresting you for stealing a whole bunch of fur coats. He said, man, I ain't got nothing to say to y'all. I know what my rights are. You just read them to me, and I'm exercising my right to remain silent. Now, once he does that, under Miranda, the cops ain't supposed to talk to him. So what this detective does, Frank is in his cell, the detective doesn't say anything to him. He comes over there, throws all the furs in front of him, about a foot from him. And Frank immediately grabbed the wire mesh and asked to speak to a prosecutor. And he was told by the detective, prosecutor can't do nothing for you here, Frank. And then Frank said, look, man, I can't afford to do a lot of time. What can I tell you that's going to make it easier on me? Here's your question, students. Was this statement obtained? Was this interrogation? Remember, any statement said that is reasonably likely to elicit an incriminating response. So in other words, now keep in mind, Frank is telling the cops initially, I don't want to talk to y'all. You said, and the rights you just read me, I have a right to remain silent? Okay, I don't want to say nothing. Now so they can't talk to him. But so how can we get him to say something? So what the cop does is he goes in and he just throws the furs that Frank is accused of stealing right in front of him, right in front of the jail cell. And so Frank, he's like, man, where'd they get that from? They got the stolen merchandise. So Frank is like, hey, look, man, I need to talk to a prosecutor. Like right now. Right? So the detective says, hey, man, ain't no prosecutor going to be able to help you. Frank said, look, man, what can I do so this can go easier on me? Next thing you know, Frank makes a confession. Now he comes and sees you. And you remember that in this case. And you start, you remember, okay, was this designed to elicit an incriminating response? Is this interrogation? Is this questioning? What's the answer? The New York court held that it was interrogation. And if it is interrogation, that means that they violated your client Frank's Fifth Amendment right. Because remember, he said, I have a right to remain silent. And you can't question me. Right? And you did anyway. That violates my Fifth Amendment right. And so whatever statement I made after you violated that right can't come into evidence against me. You got to throw my confession out. And the court said, yeah, the New York court said, the court found significant that the detective placed the furs in front of the cell after Frank had asked to speak to a prosecutor. The detective thus knew that the defendant had something on his mind that he wanted to talk about but would not reveal to him. If Frank was guilty, he presumably knew that the furs were in his co-defendant's possession, and that made the situation bleak. All right. Here's another one, another hypo. I gotta get some water. So look here. Police took James into custody for the murder of his baby. They gave him I know most of y'all don't want to represent James after I just said that, but for purposes of this hypothetical, you're going to be James's lawyer. So they took James into custody, your client, for the murder of his baby. They gave him Miranda warnings, and he said that he understood his rights and would talk to them. But he says, I want my lawyer present when I talk. Right? So, not right. You have the right to what? An attorney. If you can't afford one will be appointed to you. So once he says, I want my lawyer with me, he's doing what? He's exercising his constitutional right to counsel. And the police said, well, look, ain't no lawyer available, but one could be appointed for you when we transfer you down to the jail. And so then he says, well, look, man, so I want to tell you about it. One detective then said to James, God takes care of little babies. The baby is already in heaven. James asked the detective, are you a religious man? The detective responded, not as religious as I should be. James then began telling police how he had hit the baby and thrown it into the backyard. Is this an interrogation? Right? Are these statements designed to elicit? Now, James, keep in mind, James, your client comes in to see you. He said, man, look, I asked for you. Yeah, I told them, when they read me my rights, I said, I want my lawyer. I asked specifically for you. And they said, well, we can't find one right now. They couldn't find you right now, but they would try to find one once we got to the jail. So I was just telling them, look, if I got my lawyer, I still want to talk to you about what happened. And that's when the detective says, well, hey, you know what? God takes care of little babies. He looked at me and said, James, the baby's already in heaven. And I asked him, I said, are you a religious man? The detective responded, not as religious as I should be. And so, I just felt some type of spiritual connection with this detective. And so I told him what happened. That I hit the baby and threw it in the backyard. Now, again, I know you guys don't want to represent James. I understand. But he's entitled to a lawyer, and you just happen to be his lawyer. Interrogation? I see. I don't have commercials on this channel, so I have to drink when I can. So, all right, water when I can. All right, so look. Let's see what the answer is. The Louisiana Supreme Court held that this was not interrogation under Ennis. Remember, Ennis is the case that all this started from. And it was harmless error. The court said that the statement about God was more in the nature of consolation. James, I'm just going to console you. Then one the officer should have known was reasonably likely to elicit an incriminating response. It's a close case. That's a close case, right? Because your point, because you being the skilled lawyer that you are, you argued to the judge that they was playing on my client's guilty conscience, trying to get him to out of guilt to say something. That's the only reason why they're having this conversation. And the reason why they're doing that is because he exercised his right to his lawyer. And they knew, because what he told them was, look, I'll talk to you when my lawyer get here. But see, what most police officers know, and rightfully so, is that once the lawyer get here, he going to tell you not to talk. Or she going to tell you, hey, man, shut up. Like I used to tell my clients, hey, if you commit a crime, the smartest thing you could do is right after you commit that crime, take a sharp knife and cut out your tongue. Cut it out. That way you won't be running your mouth, because that's how most people get convicted. But, all right, so here's your bonus round question. For those of you that have gotten so far, have gotten it right, and even if you got it wrong, here's your bonus round. Sam walks into the sheriff's office and states, "I done it. I done it. Arrest me, arrest me." And the deputy asks, "Man, what'd you do?" That should be Sam, not Same. Sam, or Same as some people call him. Sam replies, "I killed my wife." "What did you kill her with?" asked the deputy. "With an axe. That's all I had." These are real cases, right? So with an axe, that's all I had. Are these statements admissible under Miranda? Remember, you need both custody, which means a reasonable person would believe that they ain't free to go, right? Functional equivalent of an arrest, and interrogation. Now look at that. So Sam walks into the office and states, "I done it, I done it. Arrest me, arrest me." So let's take it one step at a time. Is Sam in custody at that point? No. All right, now, a deputy asks, "What did you do?" Now, Sam, Same as some people call him, replies, "I killed my wife." Right at that point, the question to you should be, would a reasonable person believe, as far as custody is concerned, that they're free to leave now? Right? And so if you believe that once Sam says, man, he walks down there, he says, "Arrest me, arrest me." You say, "No, he's not in custody yet." Then the detective says, "What'd you do?" "Man, I killed my wife." If you believe he's in custody now, in other words, even though the police didn't say you're under arrest, most reasonable people would believe once they confess to murder, they may be under arrest. If you believe that, then the question becomes, when the officer says, "What did you kill her with?" should he have read Sam his Miranda rights before asking that question? Right? "Would you kill her with?" And then Sam, "With an axe, that's all I had." So now Sam, who you also know as Sam, comes to the office. I know you guys don't want to represent the axe murderer Sam, but again, the judge has appointed you on the case. What's the answer? This is your bonus round question. And here we go. The initial outburst, "I done it, arrest me," is of course admissible because, so that's going to come into evidence, right? You have to tell Sam, "Look, man, that's coming in because you made this statement, you weren't in custody, so they don't have to read you your Miranda rights." Right? It's not in response, and plus they didn't interrogate you. You come down there running your mouth, talking about arrest me, I done it. Right? But the statement, "I killed my wife," is in response to a question. And that question was, what did you do? Right? The state's only argument, so the prosecutor and the police are going to argue he wasn't in custody. Even then, he wasn't in custody. Right? Because you can't create custody by walking off the street and demanding to be, you can't walk into a police station and say, "I want you to arrest me right now," and then you create custody. Right? So the argument has to be that "I killed my wife" would be admissible because he's not in custody yet. Right? But the next question is harder. At some point, a defendant who confesses to criminal conduct in front of a police officer cannot reasonably expect to be able to leave. The point might be reached, and let me get myself off the screen so I can read the rest of this. Right? The point might be reached when someone admits to murder. If so, there's both custody and interrogation when the officer elicits a statement about the acts. All right. And so that's class for today. Now, I hope you've enjoyed this as much as I have. I hope you got your answers right. And again, subscribe to the YouTube channel so you can look at all the videos. And I'll post our next class sometime this weekend and what time it's going to be next week. Make sure that you keep your constitutions handy. Nowadays, they come in handy. And I'll see you guys at the next class session.